Today I am going to discuss what is judgment, what is decree, what are the essential elements or components of a judgment, and what is ratio decidendi. Friends, this is very important, and a question is always asked from this topic. This comes under the Code of Civil Procedure 1908. In short, we can say CPC 1908. Now, let us start. What is judgment? Judgment comes under section 29 and it is the judge's statement. It is the statement made by the judge explaining the reason for a decision. Whatever the judge takes decision, so that statement made by the judge in writing or oral is the judgment. Decree comes under section 2.2. It is the formal conclusive expression of that adjudication, determining the rights of the parties. Now I am going to discuss in detail. So judgment comes under section 2.9 of CPC. It is the written or oral statement of the judge outlining the basis for final decree or order. So friends, you can say that judgment is the written or oral statement made by a judge explaining the basis of his decision regarding a case, and facts, issues and evidences submitted to the court are analyzed by the judge. Every point of that suit is resolved by the judge through his reasoning. He explains why the decision was made. Thus, the judge in his judgment gives the reasons for his decisions, but it is not directly executable. This judgment is not as directly executable because it is the outlining of the judgment, and when decree is made, then in that it is elaborated. The case is fully elaborated. The decisions are fully elaborated. So this is not directly executable. Now decree section 2.2 CPC. What is the definition of decree? The formal expression of an adjudication that conclusively determines the rights of parties regarding matters in controversy in a suit. It means the decision is written elaborately, and the reasons for taking these decisions and the rights of the parties involved in the suit is fully written in a legal manner. The actual relief granted. What are the contents of the decree? The actual relief granted. Here it is elaborately written. Relief granted to the parties, costs involved in the case, and what are the rights of the parties. The nature, the formal legally binding order derived from the judgment. Its nature is formal legally binding order. It is a legally binding. It is enforceable and derived from the judgment. So friends, as already I told you, the types of decrees may be preliminary. In preliminary decree, some points are decided, settle some rights. Final completely disposes of the suit. It means all the points mentioned in the suit where controversy exists has been resolved, or partly preliminary. In this case also, some points are decided and some points are still to be decided. Decree is capable of execution. Decree is capable of execution, but judgment is not executable. It's not capable of execution. This is the difference between the judgment and decree. Now, I am going to establish a relation between judgment and decree. What comes first? The judgment comes first and then followed by decree. So, first of all, judgment is decided of the case and then decree follows. And decree, what is decree? Decree contains the broad details of the judgment. Judgment explains. It means judgment gives the reasons why the decision was made. So judgment explains, decree directs, and decree, which has been written in an elaborate manner in a legal way, is enforceable. It directs to follow both the parties. A decree must arise from a suit. A decree must arise from a suit. It means whatever decree is there, that must, based on the decisions taken in that particular suit. A judgment can be in other proceedings too. The decision made by the judge may also refer some other case and might have given some decision based on that, which may be similar to this case. But decree always takes into account the development of that suit. It means whatever the decisions regarding the points mentioned in the suit must be resolved by the judgment, and that should be elaborated in decree. So decree must arise from that particular suit. A decree is the instrument of execution, but judgment is not. So these are the, you can say distinction, you can say relations. So this is all about decree and judgment distinction. Now essential elements of judgment. Before a judge takes some decision, there must be some elements to decide on the basis to decide the case. A concise statement of the case. A concise statement of the case. Issues involved. What are the issues? The judge must know the issues, and whatever the court's decision is there, whatever the findings of the court, and detailed reasons for that decisions, all delivered formally in open court. Judgment is delivered in open court by the judge, which has been outlined in order number 20, rule 4 of the CPC and section 29 of the CPC. So the judgment must be delivered in an open court, and it may be in writing or in oral, both. The judgment must explain the grounds for the decree. The judgment must explain the grounds for the decree, addressing evidences and arguments, leading to a final clear operative part, granting or refusing relief, ensuring transparency and guiding future cases. These two lines you can understand. This is all about the judgment and decree. The decree which is elaborated is based totally on the judgment, which explains the reasons for taking the decision. So decree should be transparent, final, and granting or refusing relief all should be mentioned. But this is based on the judgment. Now, friends, let us discuss what is ratio decidendi. In simple words, you can say reasons for the decision. It is very important. No decision made by a judge be without reasons. He must give reasons for his decisions. That is ratio decidendi. It is the main legal reasoning principle or basis on which a court's decision rests. It means without reasons, no decision can be taken by a judge. He must mention the reasons for taking the decision. So it is a binding statement of that legal issue in a case. So it sets as a precedent. When a case comes to the court and just has explained the case in a unique manner, and he has also explained how he has arrived at the decision, and he has shown all the reasons which are legal and binding, so that may be treated as a precedent important for the future cases. Whenever a similar case comes to the court, this case must be referred and the decisions of the case must be binding. It is not like obiter dicta. Obiter dicta means some expression of the judge. He makes some observations and gives his own observation on a particular point. So obiter dicta is not binding on the court's decision, but ratio decidendi is binding on the court. So it is distinct from obiter dicta. Now, what are the key features of ratio decidendi? Ratio decidendi is binding on lower courts. The lower courts must follow the decisions based on ratio decidendi. Secondly, this is the essential legal argument needed to resolve the dispute, not just the judge's opinion. So, ratio decidendi is a legal argument. It is not just judge's opinion. It is the opinion of the judge may vary. So this is not judge's opinion, but it is essential to be followed because it has been taken based on reasons. So it becomes a precedent, and so it should be followed in a such manner, the decision taken in that case. So in future cases, this should act as precedent. As an example, this may be treated as an example for the case, and similar case may be based on this precedent. Now there are two examples of ratio decidendi. Order 7 Rule 11. The Supreme Court has held that the rejection of a plaint under Order 7 Rule 11 CPC must be based only on the avertments in the plaint. It means any case which has been submitted to the court or any plaint which has been submitted to the court may be rejected. But on the basis of the avertments, kathan, जो उसमें कहा गया है in the plaint, and not on the defendant's defense or extrinsic evidence. कोई बाहरी का आप साक्ष्य के द्वारा या उस डिफेंडेंट को बचाने के प्रयास में आपने प्लेंट को रिजेक्ट किया. This is not to be done. This is the decision of the Supreme Court. Order 6 Rule 16. In this case, the court clarified that for dismissal of a petition under Order 6 Rule 16, the pleading must be unnecessary or frivolous, tuksh, हिंदी में जिसको कहेंगे tuksh, which becomes the principle of law in this case. It means you can dismiss, the judge can dismiss a case, a petition, only when he finds that the pleading made in the suit are unnecessary or frivolous. And so there may be dismissal. This should be the basis. If the judge finds that the pleadings are unnecessary or frivolous, the case may be dismissed. Otherwise, the judge has to go through the case. So friend, this is all about what is judgment, what is decree, what are the essential elements of decree, and lastly, what is ratio decidendi, which is treated as a precedent for future cases. So friends, I hope you will find this topic, content of the topic very interesting for you. A question is always asked based on this: judgment, decree, elements of judgment, and ratio decidendi. So friends, thanks for watching this video. Friends, those who have not subscribed the channel, please do subscribe it.